All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much and welcome back, everyone. Court officer, please put the matter on the record for the day.
Thank you, Mr. President. Good morning, Your Honors. Situation in Darfur, Sudan, in the case of the prosecutor versus Omar Hassan Ahmad al-Bashir. Case reference ICC 0205-0109. For the record, Your Honors, we are in open session.
Thank you very much. And there are changes in appearance. I understand that somebody else has joined us. All right. If you can kindly introduce yourself, please.
I'm Yolanda Gamarra. I'm from Zaragoza University, professor of public international law. I'm working on this kind of topics from 10 years ago. Thank you very much.
Thank you very much and welcome and thank you for joining us. No more changes in appearance. Everyone is here. No. Okay. We're all the same.
Sorry, Your Honor, one of our colleagues, Mr. Amir Hadid, will be absent for this morning for official engagement. Thank you, sir.
Ambassador. Thank you. And I've been informed that Mr. Newton is also not in court. All right. We do this thing so that the record will remain the same 3, 4, 10 years down the line. We don't want somebody assuming that somebody was in the room all along when they were not. Thank you. Now, the chamber received the request Thank you very much. The chamber received a request from the representative of the League of Arab States, Ambassador Abdelaziz, to give his observations on Group B and C together during the session this morning when it is his turn to speak, because he will be unavailable from Thursday. And we've decided to accommodate that request, and for that reason we will proceed as follows. For purposes of enabling him to do so, Judge Ibanez will now read onto the record the Group C questions. That is only for the benefit of the ambassador. So when it's his turn to speak, he will speak to both at once. But for the rest of us, we reserve our comments today to Group B and then take Group C in turn when the time comes. So while we proceed in that way, and I'll invite my colleague Judge Ibanez to read the Group C questions onto the record. Judge Ibanez?
Thank you, Mr. President. Group C, Articles 86, 87.7, 97, and 98.2 of the statute. Question A. What types of international agreements are covered by Article 98.2 of the statute? And does the 1953 Convention on the Privileges and Immunities of the Arab League fall within its scope? B. Article 87 of the statute enjoins states parties to cooperate fully with the court in its investigation and prosecution of crimes within the jurisdiction of the court. Thus, this obligation includes the duty to arrest and surrender persons in respect of whom the court has issued arrest warrants, leaving aside any question of immunity. C. How should the general obligation to cooperate fully with the court in Article 86 of the statute be understood in light of Article 27.2 of the statute and paragraph 2 of the Resolution 1593? D. In what circumstances, if any, could it be desirable for the court to refer a state to the Assembly of State Parties and or the Security Council in respect of non-compliance pursuant to Article 87.7 of the statute, when it is no longer immediately possible to obtain the specific cooperation requested, such as in the present case when Mr. al-Bashir was no longer present on Jordanian territory at the time of the referral. E. What specific actions, if any, were taken by the Hashemite Kingdom of Jordan to communicate to the court the difficulties encountered in its execution of the arrest warrant in respect of Mr. al-Bashir in accordance with Article 97 of the statute? F. What specific action, if any, has been taken by the African Union and or the Republic of Sudan to address the alleged gross violations of human rights committed in Darfur? Thank you, Mr. President.
Thank you very much, Judge Ibanez. Now we will continue where we left off yesterday, and that would take us to the observations from the African Union. They will speak to Group B questions for 25 minutes. And after that, the League of Arab States may then speak to Groups B and C. Council.
Mr. President, honorable judges of the Appeals Chamber, learned counsel opposite, good morning. It is a great honor to appear before you today in my capacity as external counsel representing the African Union Commission. Your honors, my task this morning, as Ambassador Negem indicated on Monday, is to address the Group B questions. Since we only have about 25 minutes, addressing each of the 15 questions would leave me roughly 1.5 minutes per question. Yet, some, if not all, of the questions in Group B cannot be fully addressed in so little time. For these reasons, I appreciated that you stressed over the past 2 days that the questions are intended to be a guide and need not be answered individually. Consequently, while I will do my best to take up as many of them as possible, I will be selective and focus on the especially important ones based on the submissions so far. Additionally, I also want to save a few minutes for the end to share several responses to the prosecution's arguments on this important cluster of questions that in many ways are at the heart of the legal quandaries in this historic appeal. Your Honors, questions A and B concern the powers of the Council under Chapter 7. I have 3 main points to offer. First, as a textual matter, given the nature of the Charter and the body it created, the issue of immunities for persons accused of international crimes were not contemplated either by Chapter 5 or Chapter 6. Neither does Chapter 7. The Charter Articles 24 to 26, 39 to 42, which explain the functions of the Council and empowers it to take binding decisions that all member states must abide by, certainly do not explicitly entrust the Council with any power to, quote, waive, displace, or override the immunity, unquote, of heads of state under customary or conventional international law.
Mr. General.
So even under Chapter 7, which is the Council's most robust power, there is no express textual red override button provided for immunities. Even if it did, I am not sure whether we should assume that the Council might have pressed it in relation to Sudan. Second,
Council, I have to, we have this pace warning we give from time to time.
I apologize, Your Honor.
Not too fast, but not too slow that we all fall asleep.
Okay.
Calibrated somewhere.
I'll do my best, Your Honor. Second, I was going to move to my second point. The Charter does not give the Council any powers to, quote, make conventional provisions, unquote, of any treaty applicable to states that are not parties to those treaties. The Council is not a world legislature. Thus, to suggest as much would be to imagine a breathtaking power that sovereignty-conscious states would not have accepted back in August 1945. It is certainly not one that states would accept in September 2018. Any such legislative powers will also step on the sensitive toes of the General Assembly, which in Article 13(1)(a) of the Charter was actually mandated to promote international cooperation in the political field and to encourage the codification and progressive development of international law. Third, there are, of course, some exceptions where the Council has in its practice adopted Chapter 7 resolutions with general and abstract obligations that have been deemed quasi-legislative. For example, Resolution 1373 on terrorism financing and Resolution 1540 on weapons of mass destruction. Resolutions 827 and 955, which created the aptly named Chapter 7 tribunals for Yugoslavia and Rwanda, have been described as quasi-legislative as well. But having said that, the resolutions creating the ICTY and ICTR differ in their legal character from those on terrorism and WMDs. They, inter alia, established new and independent legal bodies that are also subsidiary organs of the Council under Article 25. Therefore, analogizing resolutions
Mr. General,
827,
is it really about being a legislator, or is it about perhaps being an executive arm of an institution? Liken it in this way. In the national system, there's a law that says human beings or citizens' autonomy to be respected. There is no assault permitted in the national system. Assault meaning touching somebody. It's an assault. But the police is entitled to arrest somebody. When they do that, are we looking at legislative function of the police, or is it a matter of executive? Can we liken that to what the Security Council does under Chapter 7?
Your Honors, thank you. I only made reference to the idea of legislative because in a way, when you think about the role of the Council, there's a debate as to the extent to which it can bind member states of the United Nations.
But it is about immunity. And immunity, again, the example I gave you, there is something of immunity in it, in the sense that the citizen is immune from assault in the ordinary sense as a matter of relations within the state. I'm not allowed to touch you in a way you don't want to be touched without your consent. It's a different matter if the police are doing their work. So that immunity that human beings have, or citizens have in a state, is there, but the police can override it. That's the kind of distillation I'm looking at here.
Thank you, Your Honors. I have a couple of very quick observations to make. I do have in the remarks that I've prepared an aspect that deals with the role of the Council relative to the question in the sense of the executive. So if that would be permissible, I could come to it later on, if that is okay, Your Honors. Okay, thank you. Because then I actually was just referring to the international criminal tribunals for the former Yugoslavia and Rwanda, and was trying to suggest, Your Honors, that they are distinctive in the sense of the adoption of resolutions 827 and 955, whereby the Council, in comparison to the Article 13 referral power, would indeed be able to exercise some kind of executive authority and bind, of course, under Chapter 7 states. But both in relation to, in the particular context of this case, to the question of immunity raisonne materia, and more directly to the particular questions in appeal, the duty of third states such as Sudan, or such as Jordan or South Africa, to cooperate fully and arrest a suspect, such as Mr. al-Bashir of Sudan, in relation to immunity raisonne personae. Let me just start very quickly with immunity raisonne materia. In the ad hoc tribunals, a plea based on official capacity, Your Honors, is irrelevant to prosecutions when the suspect is before the tribunal. That is the same as Article 27.1 of the ICC statute. So he could not plead functional immunity had the Council instead created a new ad hoc international criminal tribunal for Sudan, modeled on the template of the Chapter 7 tribunals. And I'm, of course, referring here to the question. The plea of official capacity as a substantive defense to criminal responsibility would in any event be unavailable under customary international law as per Nuremberg Principle 3. But that immunity type is not an issue regarding the exercise of criminal jurisdiction here. The key is that he must be before the court before such a claim could be asserted. For now, he is not. If he ever does come, say after he is no longer in office, like Mr. Taylor of Liberia, and if he does then make the argument at the ICC, as did Mr. Taylor at the SCSL, the answer would be simple. It is in Article 27.1 and in 6.1 of the statutes of those two tribunals. As Mr. Taylor knows, those immunities did not help him to avoid trial, conviction, or punishment. If anything, far from benefiting him, his head of state status was used as an aggravating factor by the special court when determining his sentence in light of his special responsibilities. Thus, the more pertinent comparison then is the binding effects of the cooperation established for those international criminal tribunals vis-a-vis Article 27.2 for UN members in relation to ICC non-parties like Sudan that have not yet waived their customary law immunities under Article 98.1. In the context of the Chapter 7 tribunals, and this is a major contrast in my view to the Sudan scenario, all UN members were obligated to cooperate with the ICTY and the ICTR in Articles 28 and 29 of their respective statutes. States were, in Chapter 7 resolutions, unequivocally directed by the Council to, quote, cooperate with the International Tribunal in the investigation and prosecution of persons accused of committing serious violations of international humanitarian law, unquote. So, had they arrested a sitting head of state, they would have...
warning.
Okay. I apologize, Your Honors. I naturally speak very fast. I have to slow down. I understand. Thank you. Do my best again. So, had they arrested a sitting head of state, they would have a legal obligation that they could point to that when combined with the supremacy clause in Article 103 of the UN Charter gives counsel imprimatur to their actions under international law, to the extent that they would have had contrary obligations under other international agreements, of course, as did Jordan in respect of the Arab League. The states were further directed by the same council, which notably did not impose this same duty to arrest on all states in relation to the Sudan referral to, quote, comply without undue delay with any request for assistance or an order issued by a trial chamber, including but not limited to the arrest or detention of persons and the surrender or the transfer of the accused to the International Tribunal, unquote. Subsequent Chapter 7 resolutions, especially several adopted in relation to the ICTY, urged all states to cooperate fully with international tribunals and their organs in accordance with their obligations under the resolutions established in those tribunals. Hence, contrary to what the prosecution mentioned, there are some significant legal differences between the Yugoslav and Rwanda situations on the one hand and the Darfur referral on the other. the reason being that cooperation duties were imposed only on the quote, government of Sudan, unquote, whereas Yugoslavia and Rwanda and all UN member states were subjected to the same obligations to assist the Chapter 7 tribunals, which, as the prosecution rightly mentioned yesterday, even had primacy over all national courts. In sum, Your Honors, the Security Council has not mentioned the immunities in its referral in this case, and it cannot be assumed or taken by implication that it has done so. This brings me then to questions C to E. I start with C regarding Article 13b of the statute when it provides that the court must exercise its jurisdiction in situations of council referrals in accordance with the provisions of the statute, which is found in the opening chapeau of Article 13. Here too, I have three quick points to make. Firstly, it means that the ICC can only act as provided for in its constitutive instrument. Second, it also means that the ICC could be given jurisdiction where it would not otherwise exist. It still has to follow its statute. What it does not and cannot mean is that it magically transforms Sudan into a state party or something akin to one. Otherwise, why does it not have to pay membership dues, attend ASP meetings, or nominate a judge for the ICC bench? Is forced membership by indirect Security Council imposition free membership? Is membership a one-way street, only obligations and absolutely no rights? Third, and finally on this point, Your Honors, the 13b language, in accordance with the provisions of this statute, is also an umbrella or a shield for the ICC. Otherwise, what is to prevent the Council from amending the legal framework of the ICC statute by, for example, altering the subject matter, personal or temporal jurisdiction of the ICC through its Chapter 7 resolutions? Your Honor, several questions focus on the potential applicability of parts or a whole of the ICC statute to the Sudan situation. Here, we are wowed by legal gymnastics on the interactions of the UN Charter and the ICC regime and the magical reign of Resolution 1593. Let me turn to the pretrial chamber decision to illustrate these magical tricks that you should not try to perform, Your Honors, as the ICC's highest court deliberate on this appeal. The first point to make about the decision of the pretrial chamber is that it does not per se turn on interpretation of the ICC statute for the conclusion. The chamber determines that under the ICC, a serving head of a non-state party would have immunity both from the jurisdiction of the court and from the authorities of potential cooperating states. The same reasoning was reflected in the South Africa decision. The chamber found that Mr. Bashir does not enjoy immunity from arrest by state parties, and therefore Article 98 does not apply, because the Council, when referring to the Darfur situation, implicitly waived his immunity. The chamber determines that paragraph 2 of Resolution 1593 constitutes an implicit waiver of Mr. al-Bashir's immunities. With the permission of the chamber, I wish to quote paragraph 2 of Resolution 1593 in relevant part. Decides that the government of Sudan and all other parties to the conflict in Darfur shall cooperate fully and provide any necessary assistance to the court. In our view, turning to the questions of how to determine its jurisdiction through Council resolutions, the next question calls for proper interpretation of those resolutions. The rules applicable to treaty interpretation are, of course, applicable mutatis mutandis to Council resolutions. The ICJ has confirmed this in the Kosovo advisory opinion, citing Article 31 of the VCLT and noting that it may be applied to the interpretation of Council resolutions, as have several chambers of this court. While the ICJ in its advisory opinion just mentioned cautioned that the peculiarities of Council resolutions may require consideration of additional elements, it proceeded to apply the Vienna rules to the interpretation of Resolution 1244, which concerned the setting up of UNMIC. How then do we interpret Resolution 1593? It is through the application of Article 31 of the VCLT, which, as Your Honor knows, states a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty, in their context, and in light of its object and purpose. Like Jordan, and perhaps even the OTP, we submit that this requires a consideration of three interrelated elements. One, the ordinary meaning of the terms of paragraph 2. Two, the context in which they appear, which includes the rest of Resolution 1593. And three, the object and purpose of Resolution 1593. We submit that each and every one of these three elements support the interpretation that operative paragraph 2 did not affect the immunities of Mr. al-Bashir because of the automatic application of Article 27 and that Jordan therefore remained under an obligation to respect his immunities, which means, contrary to the pretrial chamber decision, Article 98 continues to apply. I would have wanted to proceed to examine each of these elements in turn, but for the sake of time, I'm going to skip them. If the honors would like to hear the submission, I'll be happy to come back to them. So we will submit in respect of this element that paragraph 2 of Resolution 1593 does not relate to immunities at all. Even if, which we do not accept, paragraph 2 shows somehow immunities were implicated, the ordinary meaning of paragraph 2 suggests that Sudan would be obliged to waive immunities. Failure to do so, assuming that's what paragraph 2 required, would result in state responsibility for non-compliance, but would not in and of itself amount to a waiver. So on the clear terms of the words, paragraph 2 is not self-executing. Very briefly on the second element of context, if we look at the context, we find there is nothing in the resolution that suggests a waiver of immunities. If anything, context suggests that immunities are not affected by the resolution. Furthermore, as part of context, we submit that in this resolution, the Council has made it plain the intention to deviate from existing rules when it has sought to do this. In particular, looking at paragraph 6 of the resolution, which the Chamber asked about in question L, the Council departs from two important rules of international law. In so doing, it makes plain its intention, much in the same way it did in an earlier Chapter 7 resolution, 1497 of 2003, concerning Liberia. One, once the ICC has jurisdiction over a situation, nationality does not play a role with regards to its jurisdiction over particular cases. Paragraph 6, however, purports to exclude the court's jurisdiction over the nationals of non-parties in certain circumstances. That we highlight this provision in no way suggests our view as to its validity. 2, furthermore, under international law, a state determines its own jurisdiction, subject, of course, to any prohibitive rules. Paragraph 6, however, similarly seeks to oust the potential universal jurisdiction of states over crimes committed by non-nationals in those circumstances. The resolution cannot, therefore, be reasonably construed, in our view, as recognizing other exceptions by implication. Indeed, even if the paragraph 6 exception generated very serious pushback within the Council, Your Honors. That is manifested by the statements of Brazil, which you may have alluded to, I think yesterday, Your Honors, which called the carve-out, quote, a legal exception that is inconsistent with international law, unquote. And that of Denmark, which considered that, quote, the ICC may be a casualty of Resolution 1593, unquote. Since, according to Denmark, by limiting the reach of the ICC and subsuming its independence to the, quote, political and diplomatic vagaries of the Council, unquote, the exceptions contained in operative paragraph 6 of the resolution, quote, is killing the ICC's credibility, softly perhaps, but killing it nevertheless, unquote. All this goes to show that there is a great danger, Your Honors, in endorsing the recognition of exceptions by implication, one that other states, including those on the Council, would themselves prefer to know in advance to allow for proper deliberation and decision-making. Overall, then, Your Honors, the correct position in our minds is this. If the Council had the intention to deviate from the rules on immunity, it would have, similar to the ouster clauses that have done so expressly. Very briefly on object and purpose, Your Honor, it's clear from a review of the resolution, a holistic review, that the resolution is multifaceted. The jurisdiction of the ICC is but one cog of a wider strategy, which had been preceded with the Commission of Inquiry and the establishment of peacekeeping mission to Sudan. Jurisdiction of the ICC cannot thus be achieved at all costs. Mr. President, ordinary meaning, context, and object and purpose all support the interpretation the resolution does not address and thus leaves the rule of immunity under international law intact. Mr. President, Your Honors, I indicated at the outset that I'll try to respond to some specific points raised by the prosecution yesterday. I wish to submit 6 specific observations for your consideration. 1, the overall theory that Council Resolution plus Article 27.2 minus Article 98 is so complicated and so obscure that it seems far-fetched to imply that the Council, quote, necessarily intended unquote, its resolution to have such drastic legal consequences. I hope to speak to this a little bit more tomorrow. If this interpretation of the meaning of the resolution was so obviously intended, why did it take the ICC pre-trial chamber 17 years to identify this as the correct legal theory for stripping away immunity? The truth is that it is much more likely that the Council had no such intention, and if the Council's members had focused on the issue of foreign criminal jurisdiction, the most obvious understanding would have been that Article 98 will resolve any possible conflict.
What's the significance of 17 years you mentioned?
I'm sorry, Your Honors?
What's the significance of 17 years you mentioned?
Your Honors, the significance is only to point to the non-obviousness of the question.
Was that question pending for 17 years?
Well, it took the chamber quite a while, Your Honors, to
From when
make the
to
ruling.
when?
So from the passage of the resolution in 2005, to the issuance of the earlier decisions. So the suggestion, Your Honors, is that it's not so obvious that this was the intent. My third point is that it can hardly be said that immunity from criminal jurisdiction renders the referral meaningless, and that has been suggested over the course of the past few days. Certainly, as of March 2005, the referral had very real meaning, even if head of state immunity was unaddressed, since it's one, persons other than Sudan's head of state or foreign minister would not have had head of state immunity. Two, Sudan's head of state or foreign minister, if indicted, might voluntarily surrender to the ICC. We saw that happen in the Kenya situation. Three, Sudan's head of state / foreign minister might fall from power and thus lose their immunity. And of course, I mentioned earlier, this happened to Mr. Taylor in the context of the special court. He was no longer in office, so it was possible to have Nigeria transfer him to the special court by request of Liberia, and of course with the support of the international community, in particular the Security Council. Three, Sudan's head of state might, sorry, I addressed the third question already, and the final point was to say, if such circumstances did not come to pass in this particular case, the Council could, of course, have returned to the issue. And we heard yesterday a discussion with Mr. Wood about the difficulty for the Council, or at least the lack of practice whereby the Council returned to a particular question. Fourth, one cannot conclude, Your Honors, from the Council's referral when we look at the second instance of a referral, and this, of course, is the reference to the Libya situation, whereby the Council adopted anything about a theory supporting the stripping away of immunity. I mean, there had already been a debate, Your Honors, with respect to this particular question, and the Council was aware of that debate and yet adopted more or less, with some changes, the same resolution with the same limitations imposed on the jurisdiction of the International Criminal Court. Five, the UN ICC cooperation agreement was helpfully pointed to by the Office of the Prosecutor yesterday. Article 19 of that explicitly addresses the issue of waiver of immunities of persons who fall within the jurisdiction of the court, but says nothing about waiver of immunities of state officials. Six, the indictment and issuance of arrest warrant by the SCSL and the ICTY in respect of Milosevic and Taylor do not strike me as that relevant for interpreting the referral to the ICC in the context of Chapter 7. Your Honors is very familiar with the work of the Special Court for Sierra Leone, and you are, of course, aware I was duty counsel in the Taylor case. And in the Taylor case, a key point of distinction would be, first, the legal nature of the tribunal. The Special Court for Sierra Leone was never established on the basis of Chapter 7. Rather, it was the first treaty-based international criminal court whereby there was a bilateral agreement between the United Nations and one of its member states, in this case, Sierra Leone. It was not rooted in Chapter 7, and the tribunal, in the Taylor decision and a number of other decisions, had to address that particular question. It essentially responded that we're an international criminal court.
Watch time. Your time's not up yet, but we've got about 5 more minutes.
Thank you, Your Honors. That's very kind, and I will be able to finish my points. The second point I was going to make, Your Honors, about the Special Court for Sierra Leone is that one has to look at the duty to cooperate that flows from the bilateral nature of the agreement between Sierra Leone and the United Nations. Essentially, the Council and the Secretary General acknowledged that there was no possibility of doing something similar to the ICTY and ICTR, whereby it could impose binding obligations on all other states. Rather, the only duty to cooperate with the tribunal in the sense I was discussing earlier, vis-a-vis the Chapter 7 tribunals, was only on Sierra Leone. Even Liberia, which had been implicated in the conflict in Sierra Leone at the time and had Chapter 7 decisions by the Council admonishing it for doing so, had no party status to the treaty. So therefore, even Liberia could not be said to have been bound. Lastly, with respect to the special court, we know, of course, ultimately, after Mr. Taylor had stepped down, he was transferred to The Hague. The legal basis for that transfer effectively was a Chapter 7 resolution, Resolution 1688 of 16 June 2006, whereby the Council requested all member states of the United Nations to cooperate with the special court and to assist it to ensure that Mr. Taylor could be tried in The Hague. So, Mr. President, with those brief 6 points in rebuttal that I wanted to raise in reaction to the OTP submission, I conclude the main part of my remarks. I'm happy, of course, to take any questions that the chamber might have. I'm in your hands.
Not a technical question as yet, but just a small matter for clarification on the Charles Taylor transfer. You say the transfer was done under Chapter 7, but the court itself, the special court, was not created under Chapter 7. Was that the case?
Yes, Your Honors. And so the court was created by a treaty between the United Nations and government of Sierra Leone. But then, what I'm trying to suggest...
No, it's not about what you're suggesting.
Okay.
I just wanted to get on the record the circumstances of creation of the special court versus the matter of transfer.
Yes, Your Honor.
Mr. Taylor in the specific instance.
Yes.
That's all.
So, Your Honors, yes, the special court was created by a bilateral treaty, but on the other hand, when it came to transferring him for trial, at that point, of course, we had the Liberian government requesting he be transferred, even though he was on asylum in Nigeria. Then there was then a need, because the Netherlands had indicated willingness to try him, there was then a need for the Council to pass a Chapter 7 resolution that would then allow that transfer to be effective, because after all, otherwise there would not be an obligation at all for the Netherlands or other UN member states to cooperate. So my point is to make a comparison with the Chapter 7 tribunals, and of course to link it back to the Resolution 1593, which did not, in the particular context of this case, have a similar effect on other states other than Sudan. I hope that is helpful, Your Honors.
It is. Now, here is a technical question. You don't need to answer it now. You can answer it later. But I put it on the record now also to enable the speaker after you, since he'll be leaving, to consider it if he can. Here we're dealing with interpretation of a UN Security Council resolution adopted under Chapter 7 of the Charter. In the Tadic jurisdictional appeals decision, the ICTY appeals chamber, I believe it was in paragraph 31 of that decision, sought to make a distinction between coercive effect and mandatory effect. And everyone in their turn can help speak to this, that would be immensely helpful. And the court in that case found that in respect of the, I think he used a terminology of corporate entity or state, that the effect of the Chapter 7 power was coercive. But for the rest of the UN membership, the power was mandatory. I just put it on the record to see whether that helps us in making our way through the difficult matter we must deal with here. You don't need to speak to it immediately. You might take your time and look at the provision, also in context of the discussion around it. Sorry, the paragraph in terms of the context around it, and you can speak to that later, and everyone else. Thank you.
Okay. Thank you, Your Honors.
Ambassador, your turn next.
Thank you very much, Mr. President. Mr. President, members of the Appeals Chamber, it is again with great pleasure to appear before you today on behalf of the League of Arab States, this time with respect to Jordan's second and third grounds of appeal, along with the Group B and Group C questions. The Arab League is very grateful that the Chamber decided to accommodate its schedule so as to allow me to address Group C issues this morning. On Group B issues, with respect to the second ground of appeal and the Group B questions, the League wishes to note that its member states have a very rich history serving as members of the United Nations Security Council in accordance with arrangements that allows it to rotate between African Arab members and Asian Arab members of the League. In fact, Jordan served as a member in 2014-2015, and at present Kuwait is a council member to be followed by Tunisia starting next year in 2020. At the time of the adoption of Security Council Resolution 1593 at 2005, Algeria was the Arab member of the Security Council. Hence, members of the League have a long-standing experience with the Council and its practices. We have addressed issues relating to the second ground of appeal in our written observations, and the League wishes to reaffirm those points to you today. For present purposes, I focus your attention on the prosecution's arguments concerning the effects of Security Council Resolution 1593. In our view, these arguments are not persuasive and are based upon a wholly unrecognizable approach to interpreting Security Council resolutions. First, the prosecution takes an unjustifiable state-centric approach to Resolution 1593 by inventing a novel category of states that are not parties to the Rome Statute, which it labels as, and quote, UN Security Council Situation Referral States, unquote. Such an approach fails to recognize that the Council does not refer states to the International Criminal Court. So there is no basis for constructing such a category. Rather, the Council refers a situation to the court, and this is precisely what was done in paragraph 1 of Resolution 1593. That situation did not even encompass the entire territory of the state of Sudan, but only a portion of its territory, which is limited to Darfur. Thus, the act of referral in paragraph 1, which in turn relates to the court's jurisdiction under Article 13b of the Rome Statute, is not focused on any particular states and cannot be deemed to have resulted in consequences for any particular state. As such, there is no basis in the resolution to declare that Sudan has become a UN situation referral state. Second, no matter what label one might affix to Sudan based on Resolution 1593, the League submits that Sudan remains without doubt a non-party state with respect to the Rome Statute. Even the prosecution concedes that Resolution 1593 did not turn Sudan into a state party to the Rome Statute. Consequently, the League submits that Sudan must be treated as a non-party state for purposes of the statute, and in particular for the purposes of Article 98. Third, the prosecution asserts that simply as a consequence of the Security Council referral, which concerns a situation and not a state, a particular non-party state, Sudan, is bound to unspecified Rome Statute's obligations. The League accepts that the referral activates the court's jurisdiction under Article 13b of the Rome Statute, but does not agree that it has any further effect. In short, the prosecution argument in this regard has no basis in the text of paragraph 1 of the resolution, which essentially just mirror Article 13b of the Rome Statute. Further, the prosecution argument has no basis in the negotiating history of the resolution. No member of the Council said anything at the time of the resolution's adoption suggesting anything beyond the desire to activate the court's jurisdiction. Instead, the prosecutor argument boils down to a bold assertion that the provision for a Security Council referral would be entirely defeated if that referral did not impose upon the United Nations Security Council situation referral state all the necessary obligations of the statute, as expressed by its terms. In a considerable leap reminiscent of the waiver theory that has now been discarded by the pretrial chamber, the prosecution concludes that Sudan, by becoming a party to the UN Charter, must be viewed as having consented to unspecified obligations under the statute. Yet, regarding the Council's referral as simply activating the court's jurisdiction does not somehow defeat the purpose of the referral. It simply means that the court then proceeds on the basis of the terms of the Rome Statute that would normally apply whenever the court has jurisdiction over a situation, including Article 98. As is always the case, securing custody over indicted persons may be easy in some instances and more difficult in others. The members of the Council understood that and took no action to address such circumstances. Fourth, and perhaps sensing the difficulties of its state-centric approach, the prosecution sometimes shifts to a situation-centric approach, asserting that the resolution has the effect that the Rome Statute applies in its entirety with respect to the situation in Darfur. Yet such an assertion also has no basis in the term of the statute or Resolution 1593, and in any event does not explain why that places the state of Sudan in some special category that denies it the status of being a non-party to the Rome Statute. Such a situation-centric approach is clearly untenable for reasons previously explained by Jordan, as well as entirely inconsistent with the prosecution's state-centric approach that I previously discussed. Of course, it may be open to the Security Council when making a referral to include additional requirements, but it must do so in clear terms. And the requirements must be consistent with both the United Nations Charter and with the statute. As it happens, Resolution 1593 did impose an additional requirement upon Sudan, and upon Sudan alone, in the form of paragraph 2 of the resolution. There, the Security Council decided that the government of Sudan and all other parties to the conflict in Darfur shall cooperate fully with and provide any necessary assistance to the court and the prosecutor. This created an obligation upon Sudan that would otherwise not exist, and that would have been wholly unnecessary in the prosecution if the prosecution is correct, that the status already applies to Sudan by virtue of paragraph 1 of the resolution. In short, neither the simple referral of a situation nor the imposition of an obligation of a non-party state to cooperate fully with the court removes treaty-based immunities of that state's officials, or the immunity of its head of state under customary international law from the criminal jurisdiction of another state, since doing so would be contrary to Article 98 of the Rome Statute. This would need to have been done expressly. Mr. President, members of the appeal chamber, for these reasons, it is the League's contention that the second ground of appeal by Jordan should be granted. Let me now turn to Group C issues. With your permission, I turn now to Jordan's third ground of appeal and the Group C questions, which the League also addressed to an extent in our written observations. Assuming, arguendo, that Jordan did fail to comply with its obligations under the Rome Statute by not arresting and surrendering President al-Bashir to the court. The League considers that the pre-trial chamber's referral of Jordan to the Assembly of States Parties and to the Security Council was based on errors of fact and law, and further constituted an abuse of discretion. I begin here by noting that the appeals chamber is empowered to review and reject the decision on referral reached by the pre-trial chamber. While it is true that in the Kenyatta case, the appeals chamber found that the pre-trial chamber had a considerable degree of discretion, the appeals chamber then found that the trial chamber erred in the exercise of that discretion. One of those errors was the pre-trial chamber's assessment of whether securing compliance with the cooperation request at issues would further the proceedings, and whether further cooperation by Kenya was possible. Similar errors exist in the case, given that the pre-trial chamber paid no attention whatsoever to whether a referral was necessary to secure Jordan's compliance, or whether further cooperation by Jordan was possible. Moreover, the two factors that the pre-trial chamber invoked when making the referral are manifestly errors that must be corrected by the appeals chamber. The first factor advanced by the pre-trial chamber, which may be found at paragraph 53 of its 2017 decision, was simply the fact of Jordan's non-compliance. According to the pre-trial chamber, Jordan's non-compliance arose from a request to Jordan from the court and from Jordan's decision in March 2017 not to comply with that request. While the prosecution seeks to recharacterize this factor as addressing some extraordinary